Let us assume he's kicked out. There will be the same people who will come and say, President, you must go. President Ruto, you must go. There will be the same people who will say that. That will be opening chaos in the country. My lords, these are factors that you cannot ignore. In American jurisprudence, they never ignored that at all. When Clinton was charged with the offense of moving around with then whiskey and other women, he had quite a number of women that he was having sexual relationship with and so on. Somehow, as the state continued to adduce evidence, the Americans found that Clinton was becoming more and more popular in the country. Those who wanted to see Clinton impeached had to abandon the idea of impeachment because he was becoming a very, very popular president. And moving him out of the position of president could have brought chaos and misunderstanding in the country. So, my lords, I'm saying to you again very respectfully that please do not try to lift the conservative order as my land friends are asking for. I hope my little girls have brought my the law getting to impeachment is no longer fair or an American fair. It touches on the rule of law. It touches on human rights in our country. It touches on democracy in our country. It touches on supremacy of the Constitution, the Bill of Rights, leadership and integrity, separation of power, and the role of the judiciary in administration of justice. My lords, may I, with your permission, read to you one provision from a commentary in the Constitution of Kenya, page 150. May I read it to you? 492. This is a commentary in the Kenyan Constitution by our jurists here. And this is what they say. They say some able word, eye-opener. May I read it with your permission? This article, that is the article that is being referred to, is Article 150, dealing with the removal of Deputy President. This article, which sets out the situation that a Deputy President can be removed, protects the Deputy President from arbitrary decisions. What has been taken here is an arbitrary decision by Parliament, by the Senate, and that should not be taken by the court at all. Arbitrary decision of the President in the field Constitution. If I may pause here, there is a mention of the President. A lot of problems we have had in this country have been caused by the executive. have been caused by the president. We normally have found ourselves in this hostile area because of the acts and behavior of the president. We must tell it as it is. President Moi caused detentions. He acted rashly by putting people in detention. We have had extrajudicial killings because of the presidency. We have had some other ills because of the presidency. May I continue, please? In the repealed constitution, the vice president could be removed very easily, merely by the instruction of the president. That is true. That's how my great friend and my great client, Jaramogi Oginga Odinga, found himself having to resign because of what was happening. Karanja, Professor Karanja, faced a similar kind of problem. He was kicked out by the president, by the roadside. The vice president could therefore have been said to be at the mercy of the president, who appointed and dismissed them at will. The current state of affairs enables the deputy president to sit a heartbeat away from the presidency, yet enjoy constitutional protection against whimsical section of the president. Let us not forget those wise words, my lords and my lady. I'm inviting you very, very respectfully. Read those words, page 492, and if it becomes necessary, incorporate them even in your own ruling. What is going on now is that the deputy president and the president probably are not getting on very well at all. In my own humble view, for the years I've worked, a person or persons with whom you are working are not always friends. Sometimes you disagree very, very vehemently, very, very strongly. You may even end up by probably abusing one another, but you still continue to work. You still continue to work. You do not have to be friends to work together. Husband and wife, is there a problem? Husband and wife, and I've handled such cases. Husband and wife may be people who do not get on very well at all. They cook separately, food in the house. They sleep in different rooms and so on. But they have made up one decision. They do not want divorce. They want to make sure that the children are brought up in a family. Russia and America are not getting on very well at all. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing, you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the president now and the deputy president do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Racheal and Dorcas, Racheal and Dorcas were great friends. Some of us were very happy that you could see two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is civilization we want. That is the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission, Mr. Lord Eric Ogola, who is, as you are presiding over the bench, please come up with a judgment. You do so, you will be opening a chapter for this country, which we may not be able to handle at all. Currently, let me remind you again, the Deputy President is enjoying poll rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the Parliament or National Assembly, which actually impeached the Deputy President, if you go through what happened, was a disaster, was disappointing. It is not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, my Lord?
Please wind up your submissions.
I'm winding up. I'm winding up. And I'm winding up on this note. My lords and my lady, I have lived enough in this country. I've lived long enough in this country, and in particular in Nairobi. When you hear a rumor, do not be so small-minded and dismiss the rumor at all. The rumor usually has got some truth. So that when you hear Paul Mwita has been bribed, don't dismiss it quickly. There may be truth in it. When you hear Kibe was seen with so-and-so, don't dismiss it quickly. There may be truth in it. This is the ability that Justice Madden had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and Besha still controls the country. It controls Parliament. It controls Senate. Let it not be said it controls judiciary. Thank you.
May it please you, Lord President of the Court, and the members of your court, we are happy to reply to our colleagues. Somebody has come from the woodworks.
My name is Nosongo. I'm here for Ruto Sheria alongside John Mariri. Sorry. I was just requesting for 5 minutes.
I'm on high demand, so I beg to leave the court. I'm going to deal with some other matters.
My Lord, just a clarification whether Kituo cha Sheria was enjoined. Last time Dr. Khaminwa made an application for Kituo cha Sheria to be enjoined, and then you enjoined Dr. Khaminwa himself.
Yes, yeah, that was done.
Yeah.
Yes, Kituo appears now as seventh interested party. I proceed?
You
5
have
minutes.
your name?
My name is Nosongo. I proceed?
Yes, please.
Thank you so much. Your Lordship and your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intention at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points. in my few minutes why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that their right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that your lordships and your ladyship, to ensure that their constitutional right to fair trial, even including during this process, so just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies. Yes. My apologies. My apologies. Your lordships and your ladyships. Your lordships and your ladyships. If I may proceed. It is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because it said ukiona cha mwenzako, kichwa cha mwenzako kimenyolewa, chako kitie maji. It is critical even for future vice presidents, deputy presidents, to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, your lordships and your ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the lordships and the ladyships to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice is not served. It's imperative that at all times justice be seen to be done in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm would be occasioned upon them, and it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their rights before the final outcome of this on the vote. I humbly pray that the lordship is not located. Thank you so much.
Thank you very much, presiding judge and members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining the conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Rigathi, by dint of Article 157, Sub-Article 7. It is important for us to go there, my Lord, and it will take half a minute. What is the language of one? It is this. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. As at the day and the time and the minute that Senate voted, the Deputy President ceased to hold office. I hope this doesn't disappoint my learned friend Racheal of Racheal and Company Advocates, who wants an apology. The Deputy President ceased to hold office. But something else happened. An intervening fact is that on Friday the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, if we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking where is the ambiguity when the Constitution has said, shall? Our first submission, there is no ambiguity, there is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of Deputy President under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So he is acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this circumstance. At 1:31 p.m., when the conservatory orders both were issued, both in Kerugoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench, and you said there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has a power to send that name to court, to parliament. He did that. Parliament has a power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the conservatory order that came from Kerugoya. Yeah.